we're going to begin. Thank you for attending. We have an all-star panel here. We have an all-star panel here to speak about software patents, and it's going to be interesting. I look forward to learning all about them also, because I'm not sure what's going on anymore, and it's good to know that others will provide guidance. So I'm going to let everybody introduce themselves just like we did in the morning panel, because that saves me from having to embarrass people by saying how wonderful they are. That gives them a chance to describe their practices. And then with that, we'll then move. And we'll start off with Mark Lemley, who will introduce himself. Yeah.
I'm still Mark Lemley.
Well, I'm Bill Coase. I'm the moderator. I do patent and copyright litigation, mostly involving software and entertainment products. Bob?
I'm Bob Goldman, partner at Ropes & Gray. I am well into my fourth decade of litigating patent cases and other IP cases in all sorts of technologies, certainly computer and software cases, as well as pharmaceutical cases, and I have collected more damages than anybody else in this room.
My name is Alan Lowe. I manage the patents and patent litigation team at Google. I started out at the Patent Office examining software patents back in 1990, and then been in private practice as well as in-house now for ever since then.
I'm Renee Lawson. I'm Deputy General Counsel at Zynga, where I oversee litigation and IP. And before joining Zynga, I was partner at Goldman in San Francisco, and before that with Traurig and Harris.
I'm Nader Mousavi. I'm a partner in Prosecution IP for Sullivan and Cromwell. I'm a tech transactions, IP transactions lawyer, and do a lot of patent licenses, cross licenses. So, for Sullivan, I was a partner at Goldman. Before that, I was general counsel of Sullivan.
I'm Tim Loomis. I'm a substitute for Mark Snyder. As you will see Mark Snyder on the I'm Tim Loomis. I'm chief patent counsel at Qualcomm. I'm responsible for managing the group of people that prepare and prosecute patents.
So I thought to begin, we look at some of the things which are making software patents so confusing, and I'll return to Renee. So Renee, there have been two much anticipated and hoped for cases that were resolved. Everything CLS at Bank and Ultramercial, have they?
Yeah, we thought we might have a different panel today. We thought everything would be clear and this would be really nice and short thanks to the Fed Circuit. That has not been the case. We got the Ultramercial decision out of the Fed Circuit last week, the CLS Bank decision last month. And many people that thought that both of these provided a really good vehicle for the Fed Circuit to bring some clarity to this long, lingering question of when is software patentable, or the step level lower than that, when is the addition of a computer to an abstract idea, when does that become patent eligible? And we're going to talk a lot about software patents and remedies to the current patent landscape, so I'm not going to delve too far into that, but the idea here was perhaps if we brought some clarity as to what is subject matter eligible for a software patent, we might help clean up some of the things that many believe are stoking the fires of the current patent landscape and the NPs and what some people view as holdups using software patents in litigation. And unfortunately, that's not the case. So I'll just give you a quick overview of where we are right now, which is not really much different from where we were a week ago or 2 months ago, with maybe one small twist. For those of you who don't have a deep patent law background, which actually I'm not technical, so we're not going to do any claim construction hopefully today. We'll try and keep this at a pretty easy to understand and practical level. The fundamentals of patent law, or Section 101, basically have a breadth of things that you can patent, but there have been some exceptions that have been added on, and those exceptions are can't patent law of nature, can't patent physical phenomena, and you can't patent abstract ideas. And it's that last category, the abstract ideas category, that's caused the rub in software and in other areas. And so the Supreme Court came out in the past few years. So first we had the Prometheus case, then we had the Wilson case, and they didn't come out with a clean test. They rejected the Fed Circuit's effort with this and just left it murky as to what's the test for when software is patentable. And the Fed Circuit over the years since Bilski has kind of been all over the map. We've had, I don't know, close to a dozen decisions. Sometimes the software is patentable, sometimes it's not patentable. And we haven't really had much clarity. And the panels, both in CLS, the en banc, and the ultra-commercial decision by Rader, both have commented about this. Both have commented that we need some clarity. We need to give some direction to inventors, to the patent office, to the courts, to the industry at large. Where are the lines? And Chief Judge Rader actually commented about the difficulty that both the Supreme Court and the Fed Circuit have had in trying to come up with that clarity. So we come up with CLS and ultra-commercial. These were two great candidates for trying to clean this up. The subject matter of those patents is kind of right in the core of what we're grappling with in patent litigation, at least on the software side these days. In ultra-commercial, the patent was for an, quote, audience engagement engine, which is basically to give the consumer the opportunity to see an offer, an advertisement, as a substitute for paying for content. And that was the invention there. In CLS Bank, it was the idea of having a computer implement a two-sided escrow. So escrows have been around for a long time, adding a computer to it, making that patentable. So both of those were great candidates for analyzing where is the line. From a procedural perspective, both of these cases seemed primed for addressing this issue as well. In ultra-commercial, the Supreme Court actually had vacated the Fed Circuit's earlier ruling. The earlier ruling had found patentability of this software patent. In light of Prometheus, the Supreme Court sent it back down to the Fed Circuit and said, reconsider this in light of what we said in Prometheus. So might be an indicator from the Supreme Court that maybe they should do something different. So maybe ultra-commercial was the one. CLS seemed a good candidate as well from procedural posture. It was taken en banc last fall, and so many thought, well, we're going to have 10 judges look at this. This is the candidate. In terms of how it came out, both of those came out differently. So ultra-commercial, the patent was found that the patent was upheld, it was patentable. In CLS, the escrow patent was found to be unpatentable. So we have, again, in addition to this collection of where the Fed Circuit coming out, two different sides of the results. And I say essentially because in CLS you had a very difficult decision. You had a 135-page opinion. You had no clear majority. You had 7 separate opinions written. And you had Chief Judge Rader coming out at the very end, the final remarks of the opinion, saying, essentially, this is completely murky, and I hope there's some clarity that comes to this, and that I see that clarity sometime in my next 25 years of being on the bench. I'm sort of improvising on what he said, but it was a very divided court, and we end up with not having a ton of guidance on where we're going to go. And so with ultra-commercial, Chief Judge Rader wrote the opinion there. He ended up with a standard that is, you have to look at the entirety. You can't pick out pieces and look for individual limitations. You need to look at everything. And he came up with this interesting language of, is there intricate and complex computer programming? Which wasn't necessarily part of the holding, that he's trying to figure out when is it enough? But no real detail on, well, when is it intricate enough and when is it complex enough? Just, is it complex? And for somebody who's not a CS degree, computer program frequently looks complex and intricate, so I'm not sure where that line is. In CLS, you had the 5-judge concurrent opinion adding this, or looking at this inventive concept. So you can't have an abstract idea by itself. What is it that takes it over the line so that it's something different? And there they were talking about inventive concept. And the definition there was focused on, was there something from a human that was added on? Was there a contribution from a human, that there was ingenuity that made it something over and above an abstract idea, something over and above a fundamental principle. And that was 5. Judge Rader sort of poked at that a little bit and said, well, that's not really the test. The test can't be that because when you're looking at patentability, you can't look at inventive concept for 101, for eligibility, because separately you have to look at novelty and obviousness, so you're blending everything together, so that can't be the test. What you need to look at is the entirety, and we see reiterated in Ultramercial his view of is there a specific way that you are taking an abstract idea and you're applying it? And that's his view. So neither of those is particularly helpful. I think there were a number of amicus briefs that were filed. We filed one with Google, a number of tech companies. EFF filed, PTO filed. Interestingly enough, PTO wants it to be this multi-factor soft test. So it's unclear as to where the law is. And
Mark?
So I just want to say a little bit about best practices are, of course, a little hard given that fact. I think the true best practice is, right, get one of the following 5 judges if you're on side A, and another of these, get these 5 judges if you're on side B. That's not terribly helpful. I guess I would say a couple of things. One is, the issue isn't going to go away. Judge Rader would very much like it to go away, and it's not going to go away. And so one of the best practices is you got to keep litigating this issue, right? You just got to keep raising it because it will go to the Supreme Court. It will happen. We'll get some guidance ultimately, although I don't think we'll ever get sort of real clear guidance of the kind you might hope for from a business perspective, because I'm not sure it's possible to get that guidance out of 101. But the second point, I think, maybe goes to both the decisions of what patents you assert, but also prosecution. I do think this idea of complex computer programming has some legs to it. Now, in the Ultramercial case, what is truly remarkable is that while there is some complex computer programming in the patent, none of it is in the claims. There is nothing in the claims that remotely limits you to any of the programming. Nonetheless, the court goes to the specification and it says, well, look, there's a big flowchart and there's a lot of detail and look at all this stuff. Now, maybe that means that they've decided that the claims don't matter for 101. I hope not, right? Because that would be a pretty fundamental change for patent law. But the other thing it might mean is that we're going to start construing the claims somewhat more narrowly and bringing in some of the limitations of the specification. And that, I think, has implications for how you write and prosecute patents. I think you want complex computer programming expressed in your patent claim. If your inventors did anything that can look like an algorithm, that can look like code, look like mathematics, while you haven't for a long time had a requirement to disclose all of that stuff, you are probably better off in a 101 world if you do disclose it. But then you need to think about the fact that broad functional claiming, which we'll talk about in a minute, may be on its way out, right? That maybe what you're going to be limited to, either because of the way you draft the claims or because of the way the courts are starting to construe them, is some version of the programming that you have written, and not just any possible way of solving the problem that you solve.
I'll just mention the transitory nature of what may be a complex program today in 5 years may be, simplistic and expressed in 2 words. I took computer science in 1968, so. And what was complicated then would be like my 5-year-old could do it now. Tim, why don't you talk Ellen?
Maybe just build off of what Mark was saying. I feel like this is a movie we've seen before back in the 1990s, where 101 was the big issue, and then it just died away, and it's been dead for, I don't know, 10 years or so, and it was not the issue. Now it's coming back. And it almost feels like we'll play this out, and it's really, in some ways, a form over substance issue. Whatever the test is going to be, people will draft claims to satisfy the test. But the interesting thing then is it'll shift the arguments in the fight to 112, whether it's enablement, written description, functional claiming, as to how broad or narrow the claims are, whether you disclose enough. So my sense is that 101 as the issue is, it's not like software patents are going to go away altogether. And it's just eventually going to shift, create a test that will shift the fight to something else. And it just reminds me of sort of the new Star Trek movie. And I don't want to ruin for anyone who hasn't seen it. Sorry, Lawson. Twice?
I think I'm there.
watching, seeing the plot, with the twist. And the twist here is the Supreme Court is going to weigh in. And I think that's the interesting thing. And whether what they're going to say makes any sense or not, it will become the test. And then I think it'll shift away, and 101 will hopefully become a dead issue.
101 reminds me of this new Star Trek movie in the sense that in neither case does the plot make any sense to me.
Let me just add one little piece that's practical.
About Star Trek or
Not
about
about Star Trek. Some of us on the litigation side have been looking at 101 post-Bilski on the motion to dismiss side and using it as an early gate. Judge Rader all but put a kibosh on that in Ultramercial by saying 101 cannot be decided early, it's too fact-bound. It was actually based on a motion to dismiss from the Central District here in California. And so I think that was a little bit disheartening for people who are out there in the trenches trying to fight MPEs and other at an early time period.
And a somewhat remarkable conclusion given that every 101 opinion until that one had said it's a pure question of law.
Yep.
And suddenly it's resounding with fact issues, so you can't resolve it on a motion to dismiss.
I just want to remind people, when the Supreme Court's been deciding patent cases, they look at cases from the 60s lately, and it wasn't until 1982 the software was patentable. And why don't you talk a little bit about that, Tim, as we try and keep on track. So what about software patents and, shall we say, their quality and nature nowadays?
We hear this term software patents being about. What really are software patents? There's no agreed upon definition. You've got patents like the one in Bilski. You've got patents that are more kind of the moving stuff that humans used to do onto the internet or onto the cloud. Then you have other things like software applications. You might download it on your iPhone. You also have things like video codecs, which take a ton of video data, manipulate that data, condense the data down, and transmit that data to your phone so you can watch a video in your backyard. You also have things like engine control systems, where there's software that actually controls your engine in your car, so you get better gas mileage that way. So, which one of these is a software patent? They're all capable of being implemented in software. Also, if you have a patent that has method claims in it and apparatus claims, and is hardware, if that hardware eventually becomes implemented in software by somebody, does that transform that hardware patent into a software patent? I don't know. So when we talk about software patents, it's important to that we're all on the same page about what they are, and I don't think we're there yet. In terms of quality, you've heard a lot of people talk about software patents. There's the bad, low-quality software patents that are out there that cause thickets or cause holdup. Before Kapos left the PTO, he had a study conducted. And his studies showed that the rejection rate, overturn rate of software patents was equivalent to those of patents of other genres. So there really is not a big difference between whatever you call software patents, the quality of those and the quality of other kinds of patents.
Can I add one twist?
Sure.
Twice as often are software patents asserted in litigation as other kinds of patents. So when we talk about the NP problem, I hear what you're saying on distinguishing by quality, but there's a reason why there's a focus on software. I didn't mean to do that.
Okay. Why don't we talk a little bit about the, we have a PTO case of some interest in this topic, and Bob's going to talk about the Versailles case. Bob?
Thank you, Dad. I will stand because I am talking more briefly when I stand. That's always good. That's always good.
Especially with our time constraints.
All right, that's good. So the case is for SAP against Versada. This was a decision, the first decision out of the Patent Office under the Covered Business Method Review statute provision that was enacted as part of the American Invents Act, right? So the American Invents Act says we're going to have post-grant review. Issued patents 9 months after a patent is reviewed. Within 9 months, you can go into the Patent Office as an adverse party and ask the Patent Office to take another look. In addition, the statute provided in Section 18 that for a period of 8 years, the Patent Office would take a look at business method patents if that met the met the statutory definition. And so the procedure began. The first day that you could do all this was last September. And who was first at the door of the patent office was SAP. SAP had 345 million reasons to be first at the patent office. That is the amount that they had been found to have, damages were found in a case down in Texas that had been tried twice. The patent was found valid, the patent was found infringed. The workaround was found to infringe as well. $345 million. SAP said, well, perhaps someone else would like to take a look at this for us. This is the Versata patent. The Versata patent is about pricing. In the prior art, you would have tables of data that says customers and what they're buying and how much they have to pay. And it's complicated because people have different prices and people are bundled and people buy things standalone and they get volume discounts and all the rest. And so SAP's solution was to do this in a tree structure, a hierarchical structure, which I was able to find, similar to the one I was able to find in my 1973 textbook of computer science from Professor Knuth. There's a tree structure with a hierarchical organization. The tables are shown further up in the charts. This is old stuff. Nevertheless, applied to pricing, commercially successful, very significant, into the patent office. Now, who has standing to petition for review? Somebody who has been sued for infringement or has been charged with infringement under that patent. Well, that certainly was SAP. On the other hand, 37 CFR section 42302B says that a petitioner can't file a petition where there is stopped from challenging the claims identified. And so there's an issue in that case as to whether or not SAP was stopped. The case had been, there had been a district court judgment, it was up on appeal. Validity, however, was not up on appeal. Nevertheless, the patent office said the district court decision is not sufficiently final. We'll take a look. All right, so what patents are covered? What will the patent office take another look at? A method or corresponding apparatus. Corresponding apparatus. So they'll look at the system claims too. A method or corresponding apparatus for performing data processing used in the practice, administration, or management of a financial product or service. All right? Used to provide a financial product or service, not limited to products of the financial services industry. The patent office says, we'll look at this. This is about pricing. Pricing is financial, and we will look at a method of dealing with financial stuff, except that the term does not include patents for technological innovations. Well, what's a technological innovation? Well, that's really the hang-up, which is sort of the same hang-up out of the CLS cases. The regulation says a technological invention. The question is whether or not the subject matter as whole recites a technological feature. Well, that doesn't help us either, does it? There is guidance in the Federal Register and the comments on these regs. You can find it at 77 Fed Reg 157, August 14th, 2012, at 48,763 to 64. What the Patent Office relied on in the SAP case was they said, look, this is computer stuff is being reported, is being recited generically without limit to particular programs, particular computers, and therefore this is not a technological invention. This is an invention about a financial thing. If I wanted guidance on what was a non-technological invention, one place to look is in the Federal Circuit Bilski opinion, 545 F. 3rd at 963. As part of the opinion, they said things that are abstract are inventions that relate to legal obligations, organizational relationships, and business risks. Those are things that the Federal Circuit identified as being abstract and non-technological. Onward. Now, what happens in the PTO? The question really for everyone who is going into this process is which way would the PTO lean? When I say which way would they lean, I remember coming to a conference at Stanford years ago in which the PTO was here. PTO comes to Stanford and they came here, and there was a slide that went up great big on the board that says mission statement. The PTO's mission is to issue patents to deserving applicants. Okay, well That's kind of a lien there, right? It's not, our job is to assess whether the patent is worth a patent, whether the invention is worth a patent or not. We issue patents to deserving applicants. So which way is the PTO going to lean in covered business method review? In both the decision to institute the review and the decision on the merits, the PTO quoted the legislative history of the covered business method review and said essentially in 1998, State Street, the Federal Circuit greatly made this broader. The Supreme Court sharply pulled it back in Bilski against Capitals, and here's the money shot. In the intervening years, however, PTO was forced to issue a large number of patents, of business method patents, many or possibly all of which are no longer valid. The Schumer proceeding, the covered business method review, offers a relatively cheap alternative and will reduce the burden on the courts of dealing with the backwash of invalid business method patents. Which way is the PTO leaning in covered business method patent review? Now, by the way, those of you who have invested heavily in a patent portfolio over the last 15 years, congratulations, the PTO, or at least this panel thinks that you may have a backwash of invalid business method patents, which they happily issue to you. All right. That's the way the PTO.
They get fees after all. So
They get fees on both sides. All right. What standard did the PTO apply in terms of assessing the patentability under 101? They found the Versada invention unpatentable under Section 101. They applied the Judge Lurie standard, Justice Breyer's standard. Essentially, you take the claim, you try to suss out what whether it's abstract or not, and then you decide whether all the other things that have been added to it make it a technological invention. The PTO expressly said an improvement in marketplace technology does not demonstrate that the additional steps are anything other than conventional resources. That is, Versada says, look, we do all this stuff. We have prices, we have people. It takes a lot of data. This is hard. Right, all the stuff from the spec, and they say not good enough. Right, and so now you have certainly a contrast with Judge Rader's standard from Ultramercial, which says this: the inquiry focuses on whether the claims tie an abstract idea to a specific way of doing something with a computer, or to a specific computer for doing something. In Judge Rader's view, if that's so, the claims will likely be patent eligible. The PTO obviously is in the other camp so far. All right? So this will go up on review to the Federal Circuit, and we'll see what they do with that. The other question just about these reviews generally is, will the district court stay litigation pending covered business method patent review? Section 18b(1) of the American Invents Act says the courts are supposed to grant a stay if the stay will reduce the burden of litigation on the court, and they make a decision not to stay immediately appealable. Well, geez, I can't imagine a Section 101 issue that a court wouldn't be glad to divest itself of and take it to the patent office as the best practice. And of course, there are courts that have now granted stays. There's a court out in Ohio that did it in a case called Progressive Insurance against Liberty Mutual, and a court in Pittsburgh that did it in a case called Sight Sound against Apple. So, if your job, best practices, if your job is to try to beat these patents, which are being pecked to death by ducks, by patent trolls, then yes, you want to think about whether you want to go back to the patent office, at least if you can find a 101 issue. On a 102, 103 issue, I'd still wait to see what the patent office does, because I've always believed that the patent office is essentially a patent owner-friendly forum. All right, and so that's where we are in covered business methods.
Thank you. So Mark, you already gave us a preview of functional claiming. Why don't you discuss what it is and what the issue is with it, what's happening to it?
Sure. So the background here is, for those of you who are not intimately familiar with the patent statute, you generally speaking interpret patents in accordance with its claims. What it covers is what's claimed, not necessarily the particular implementation you wrote. But there's an exception in the statute, in what's now Section 112F. Section 112F says if you write your claim in purely functional terms, if you write a claim element not to describe an actual machine or a device, but to describe the thing the machine or device does, that's a signal that we're going to not give you every machine or device that could perform that function, but instead that we're going to go read your specification and limit you to the machines you actually described and equivalents thereof. And this is so-called means plus function claiming. So that if I wrote a claim element means for processing data, taken literally, that could be a computer or a phone, but could also be a pencil and paper or my brain or anything else. But the court says that's a signal that we're going to not cover any possible means for processing data. We're going to figure out which ones you used, and we're going to limit you to those. Now, in those means plus function cases, in the last 5 or 6 years, the Federal Circuit has been very active in software, in making sure that you actually did give us some real working software. And what they say is if you say means for achieving a particular end, there better be an algorithm in the specification that achieves that end. And if there isn't, your patent claim is invalid for indefiniteness. You didn't tell us which of the means would actually be limited to. Well, prosecutors have started to say, well, oh, there's a simple solution to that. We won't write means plus function claims. Right? We don't want to be limited to the things in the specification. We're just going to write regular claims and not means plus function claims. But what I suggest is that we are likely to see in the next several years, and I think we've already started to see some moves in this direction, courts and the PTO taking a harder look at whether your claim language really is a means plus function claim or not. The Federal Circuit so far has what it calls a rebuttable presumption, but which has really been mostly an irrebuttable presumption, that if you use the words means for doing X, it's a means plus function claim, and if you don't use the magic language means for doing X, it's not a means plus function claim. That's not what the statute says. What the statute says is, if you write your claim without disclosing in the claim the specific structure or for method claims acts that perform that function, it is a functional claim and you should go read the specification. So what's happened in software is we have an extraordinary array of claims that are written in purely functional terms. Right? People don't write patent claims that say, this algorithm to solve this problem. They write claims that say things like a computer configured, or in some cases configurable, to achieve this result. Okay? That, I suggest, is a functional claim element. Right? That says not, here's what I built, here's what I made, but here's the result I want to accomplish. Right? Here's what I want software to do, and any program on any computer that is configured or configurable to achieve that result is within the scope of my claims. That's one of the things that's led to a lot of the patent litigation that Renee identifies that's focused on software patents. They're more likely to be asserted in part because I've written these claims in very broad functional terms, and so it doesn't matter that my idea from 15 years ago for allowing voice to be transmitted between computers doesn't actually look very much like VoIP. I can say, hey, I wrote a patent claim that says achieving the communication of sounds between computers in any way possible, and you've implemented it in VoIP, and therefore you've infringed my patent. I think we're going to see, and frankly, to disclose my bias, I hope we are going to see a move to narrow, to limit those claims by treating them as what they are, which is means plus function claims. And saying, if you claim any means for achieving the communication of sound through computers, what you actually own is not any possible means of achieving the communication of sound through computers, but the means you described in your specification and equivalents thereof. And if you've actually got an algorithm, if you actually did teach us how to do it, you have a valid patent claim, but you have one that's narrower than any possible means that allows the possibility that other different algorithms might achieve the same result and not infringe. If you didn't write an algorithm, if you've got a purely paper patent that doesn't have any description of code or how you would implement this, then your claim's going to be invalid for indefiniteness under these means plus function line of cases. We saw the White House announced a number of steps to try to tackle the patent troll problem within the last month. One of the steps, interestingly, was a direction to the patent office to start paying more attention to functional claiming and to start calling out things as means plus function claim elements, even if they don't use these magic words. We'll see how that gets implemented in the patent office. We'll see what the Federal Circuit does with it. But I will note that the Supreme Court has never had a Section 112F case. The Supreme Court has a history in patent cases of saying things, rules created by the Federal Circuit that don't seem to look like the rest of the law, like if it uses the magic words means for doing X, it's means plus function, and if not, it isn't, do not survive very well when they get to the Supreme Court. So a Supreme Court, I think, if it got such a case, is going to look at the statute and it's going to say, this doesn't say means for doing X. This says, did you actually give me a structural limitation in your patent claim? If you didn't, then we got to go find one in the specification. So, things to do from a best practices perspective. On the prosecution side, I would be aware of this issue. I would be, first off, making sure that I've actually got algorithms, that I've actually got real content in my specification, so my patent claim's not going to be invalid for indefiniteness. But I would also start to think seriously about trying to build in some software structural elements into the patent claim so they will not be interpreted as means plus function claims and therefore potentially more limited. On the litigation side, I think we're starting to see this argument popped up. It's not made it to the Federal Circuit yet, but there are some district court cases that are percolating it. And when you are faced with a patent lawsuit, first thing to do is go read those claims and say, ask yourself, right, is there actually an algorithm here? Is there actually software structure here? Or is this just describing the goal, the end result that somebody wants to achieve? You will be surprised at how often the answer is, this claim is written in purely functional terms. And I think in the coming years that may make a big difference.
Mark, I have a question and a comment. When you say an algorithm, well, what do you mean?
Yep. No,
because if you take that, if you stretch that out to cover an algorithm that is a flow chart that is in itself describing functional terms, then you're back at Gottschalk against Benson and you've got a problem.
So I think the answer is that this is going to be where the battles will be fought in software patents over the next 10 years, right? So you can imagine describing an algorithm in extremely broad, vague terms. On the other end, you can imagine disclosing source code, right?
Well, no, you can describe it in very specific terms, but they're still functional. There's lots of ways to implement it.
Well, right, so exactly, and I think, right, and the problem is finding the right level of abstraction without sort of reducing everything down to source code. You don't want a patent that said it covers only the code I actually wrote. That's not terribly helpful, right? So the problem is finding that intermediate level of abstraction. Now, part of the answer is that sometimes when we use words that are literally functional, we have established structural meanings for them, right? So an analog to digital converter, if you just take those words literally, is anything that converted a signal from analog to digital. But we actually have a meaning in the computer world. We think of certain things as analog to digital converters. And the court has said where language is literally functional but has an established structural meaning to people of skill in the art, then we'll interpret it to cover that structural meaning, and it'll be structured. So I think we will see something similar with algorithms, right? That I might be able to invoke a dynamic linked list, for instance, right? And that won't be anything that happens to achieve the purpose of linking in a dynamic way. It'll be, here's a specific category of software structures that programmers understand to be dynamic linked lists. So, right, none of this is to say we'll magically have complete certainty in our patent claims if we start focusing on algorithms. The courts have, in the indefiniteness cases, the Federal Circuit panels have disputed how much detail do you have to disclose to qualify as an algorithm. But I think we'll at least be asking the right question, right? Which is, what's the relationship between what you actually did and what the defendant is doing, right? Rather than, are you simply achieving the same goal?
Okay, I'll take one question, then we need to move on. Yes.
Mark, do you think the software structure is being different from an algorithm?
So that's an interesting question. Yeah, so I mean, I think a software structure would be sufficient. The Federal Circuit has talked about the 112 requirement in terms of algorithms. But I think an actual disclosure of software structure in the claim is probably sufficient to get you out of means plus function world and therefore avoid having to decide what's an algorithm and is it written in function.
So by that do you mean just software configured to do something?
Well, no, I think the answer can't simply be any program, right? But then you're gonna start to get to some more complex questions. Well, what about a relational database configured to achieve X, right? What I started that is, can you imagine a software structure that's sufficiently broad that it encompasses a lot of things, but is nonetheless not simply any means of achieving this goal in a computer?
But when you say a software structure, you mean something like a double linked list or sort of record forms and how things are hooked up internally? Or
This is all about words.
Yeah,
Whatever the
and
rule is.
we're going to move on, but I just will point out that you're going to be asking a political science major judge to figure out what today, some feature that 20 years ago was magic for a software programmer and now is routine, and then 10 years, God knows what it is, but it's very exciting. But how many people do prosecution, by the way? Yeah, it's going to be a hard life for all those patents you may have prosecuted using what everybody thought was the right way to do it if the rules change in this dramatic way.
I think that's fair.
Yeah, so and there's a business model for somebody of protecting patent prosecutors when the Fed Circuit or the Supreme Court comes up with some bizarre theory that is going to ruin many, many patents. So, but let's move on to another particular, especially running out of time. Nader, why don't you tell us about the Motorola/Google versus Microsoft case and some of the damage issues and the complexities that now appearing in trying to figure out how to negotiate standards essential patents.
Great, I'd be happy to. I'll try to do this in a way that doesn't lure Alan into this conversation. But
He's already, I can see smoke coming out of him.
You're trying. This is another of the battlefronts here in terms of what will be the value of patents that a party has committed to make available to the market on a reasonable and non-discriminatory basis. So these are patents that are concentrated around standards, Wi-Fi, 3G standards, 4G standards, video compression standards, and the like, all of which are central in the smartphone wars. These are the kinds of patents that drove the very, very high values of the Nortel sale to the Rockstar Consortium, which Apple is involved in. The kinds of patents that Google got its hands on when it acquired mobility, and are really considered for those who are playing at that level of either defending ecosystems or pushing forward mobile products, really essential to use upon critical patents that one needs to have their hands on, and have been perceived as such to drive those really high values. So one of the first battlefronts in terms of this sort of developing case law, sort of what are the damages? What does it mean to say that when a patent holder is committing to make the patents available on a fair and reasonable basis, what could that mean? Fair to themselves, because in light of the other agreements that they have granted to other licensees, that they should be getting a fair royalty. Fair to the licensee, in light of the commitments that the licensee will face from all the other patent holders coming to them to seek a little piece of that pie in terms of their revenues, and in light of the royalty stacking that will accumulate. When you think that we're fair, even now with the antitrust authorities becoming very interested in this issue, in this category of patents in particular, fair to the consumers and the market in terms of what the aggregate effect is of these damages and royalties stacking up in this area to end user consumer prices. So the short answer is no one really knows what is fair and reasonable. It's very context specific, but there has been a very important decision, I think, in terms of the first significant decision to lay out a detailed methodology in analyzing what is fair and reasonable in the context of a standards patent. So the setup for this case is that Motorola Mobility approached Microsoft to invite them to take a license to a couple sets of patents around Wi-Fi and video compression. The offer was in the 2.25% range. It touched Windows, it touched Xbox, so we're talking about major revenue lines for Microsoft. And back up a second, how does this fit into the smartphone wars? Well, Microsoft, which would love to have a stronger position in mobile, but in the meantime, until it's building that position, has executed a quite successful licensing program for Android. They're out there saying, if you are making and selling Android phones, you are infringing Microsoft patents and building up a pool of licensees that are taking licenses. And they've been reasonably successful in that. So this, you could look at this as in that context of motor mobility, knocking back on Microsoft's door for royalties that could offset that. In any case, Microsoft responds to that offer with a claim that Motor Mobility had breached its commitment to offer a reasonable license. And the background of the case led up to the question of whether or not Microsoft was in a position to claim breach. That is, did the duty that Mobility had to the standards organization, did that run to Microsoft as a third-party beneficiary? That was answered yes. And so then the question became for the court, how can they determine whether or not there was a breach of this duty? Well, in order to know, they would have to determine what a FRAND rate is. So that's what this case is about. Judge Robart applied traditional damages theory, Georgia-specific factors. He modified them for purposes of the application to standards essential patents. And he did I think, a few things that are very interesting and have not been done before. I think regardless of sort of the winners and losers of this case and the impact on the parties for this case, I think the reasoning in this case will be very compelling and something that future cases that deal with this will certainly at least take into account and perhaps follow. So one of the factors in determining what is a reasonable royalty generally would be what are the other comparable licenses for that technology. Mobility proffered their own other licenses, and that supported the rate that they had asked for. The response from Microsoft was no. The right thing that you should be looking at is the pools that have developed around these exact standards. So look at the MPEG-LA pool for video compression, look at the VIA pool for Wi-Fi, and there you have many licensors who have committed to the pool, and those pools have granted thousands of licenses. So what Robart did is create a hypothetical pool and said, well, if we assume that all standards patents were in a pool at the rates that had been generated by the existing pool out there, then what would Mobility have obtained? And the effect of that line of reasoning is that the ultimate damages or reasonable royalty went from 2.25% down to a fraction of a penny. So that is a huge economic impact. If this reasoning is followed in other cases, it will significantly impact the value of certainly at least any standards essential patents for which there is a pool, and actually can create quite a conundrum. I think a lot of times patent holders would have the view, well, I'm going to either play in this pool or I'm not, but if I'm not going to play in the pool, I'm not going to be bound by the effect of that pool, and I'm not going to have a commitment to offer those patents on those terms. And I think that one of the effects of this decision certainly is that the value of patents that are not subject to standards commitments, but nonetheless read on the devices that are at issue, will become more valuable. So I think it's an interesting decision. It's one I think that we'll see how the reasoning is adopted and evolves over time, but it's a 200-page decision and it's well reasoned.
Thank you, Nader. In the 10 minutes or so we have left, just to make things more confusing, Congress is considering a number of changes to the law that we already don't understand. Why don't you talk a little bit about that?
Sure, and obviously each of these topics that each of the panelists are talking about could be a conference in and of itself. And we could have a whole conference on why Robart's decision was wrong. More about
how wrong it was, or just whether it was wrong?
Where it was wrong, let's say. And patent reform certainly is one of those topics, and there are conferences dedicated to this question. So I'm going to just spend a little bit of time just kind of hitting some of the high points and where we're at, and start with sort of where we were coming into the last 6 months. I think if you look back about a year or so ago, everyone was tired of patent reform. AIA had passed. A lot of the controversial provisions that would have dealt with trolls were thrown out largely as part of a compromise. And part of it was a perception, I think, that a lot of people had that the troll problem was not a big problem, and it was a problem, it was a first world problem, a problem that big companies had. It wasn't something that really made that much of a difference, particularly for small companies. And then to the rescue, the academics came, and Professor Lemley, and Professors Besson and Moyer, and Feldman, and Chen, and others have been writing over the last 9 months great pieces that have really brought out data to show us how big the problem is. We hear the often cited $29 billion number in terms of direct costs in 2011 that companies have incurred in defending or paying out to trolls. We've seen the number of troll suits increase to 4x over the last 8 years. That in 2012, 61% of all patent litigations were brought by trolls. And that maybe even more interestingly, that 82% of troll litigation doesn't target big companies, it targets startups and small companies being $100 million in revenue or less. And so this kind of disabused that idea that this is not a big company problem or just a small problem that doesn't affect a lot of people. And when you combine this data with a lot of the stories that started coming out about some of the harassments and the types of assertions and the way trolls were doing this by being very cagey and disguising who they were and not being clear about even what patents they might be asserting and asking for $10,000, $20,000 for just hooking up a scanner to an office system, it created a lot of outrage. And so in the last 6 months, you've seen now a number of bills, maybe about a half a dozen bills coming out of both the House and the Senate, as well as Mark mentioned the White House coming out with his own set of recommendations as well as executive actions around what changes need to be made. And a lot of these are really trying to address this troll problem. And if we sort of boil down all of these proposals, and there's still more to come, and we know that there are more bills that are on its way, most of the proposals really fall into two categories. You've got the curbing litigation abuse category, and you've got the software patent quality category. And most of the proposals that are out there right now in the various bills address the litigation abuse. How do we curb litigation abuse? One of the big proposals that various people have different thoughts on is around fee shifting. And at the end of the case, who needs to pay whose bills? And there's narrower forms of this where it's troll limited and it's only something that benefits the defendants if they were to win. And then the question also becomes standard. Is it when you win, anytime you win a case, or is it only where the case was not substantially justified? So you've got a whole variety of flavors of fee shifting. You've got other proposals that are also similar in the trying to create disincentives for bringing cases. One of them has to do with discovery cost sharing. If you're a troll and you're going to try to really increase the cost against the company, you're going to ask for anything and everything. And these proposals are really centered around you can ask for certain kinds of things, but when you go outside of that, you as the patent holder or the requester have to pay for that discovery. So if you go beyond a certain type of scope of core set of documents, you pay for it. You can still get it, but you're going to have to pay for it. And another set of proposals are around heightened pleading standards. You can't just have vague claims of infringement and hope that you're going to, through discovery, be able to show some sort of infringement. You need to have specificity, perhaps as detailed as claim charts at the time of complaint. And then some proposals around transparency and who's a real party in interest, who owns the patents, who's actually bringing the suit. A lot of these are really to change the model in terms of incentives, so that right now the way the incentives are set up and the way the litigation system is set up, it really favors the troll who has very little discovery and can hire lawyers on contingency and not have to pay out-of-pocket money. And it puts the defendant companies in a position where it's very costly to defend, even if they are to win, it's millions of dollars, and oftentimes they're more likely to want to just settle and pay out some money to the trolls. And so it balances the economics of it. On the patent quality side of things, and notwithstanding, I think, Tim's comments about whether there really are any patent quality problems, I think a lot of folks feel that there are. When you look at the number of software patents that are issued, depending on what definition you have, there's as many as 1 million plus software-related patents that are out there, and they are being asserted. The litigation is just the tip of the iceberg. A lot of it is happening behind closed doors and non-litigation, and so having the cover business method program, which Bob talked about, expanded is one of the proposals to really not have it limited just to financial services types of patents, but broaden that out. So that there's another opportunity for the patent office to review these patents that maybe should never have been granted in the first place. And then some other, I would say, sort of patent quality issues. The functional claiming, I think, is one of those that might require legislative fix, or maybe 112F is fine as the way it is, and it really should be the courts applying it. And then, of course, you've got the patent office and how the patent office interprets it as well. So most of the proposals, I think, fit in one of those two buckets. The interesting thing I find is that we don't know which way this is going to go. I think there is much more recognition that there is a problem that needs to be solved. You've got the president and others who have come out and said we need to fix this. And I think one of the interesting things from a practices standpoint is the judges are paying attention too. And so Chief Judge Rader has made comments over the last 6 months talking about things that need to happen in fee shifting, even under the existing legislation. I think you have the courts not wanting the Congress to get involved and saying we can fix this on our own. And so I guess from a practices standpoint, the one suggestion I would have is when you have opportunity in your cases is to raise these issues, to give the courts the opportunity, because they are looking for these chances to try to address these issues before Congress actually acts.
Thank you, Alan. And we're over time, so thank everybody very much. Thank this great panel.